Okay, we're gonna
It's kind of a sad day.
we're gonna start back up now. Our last panel of the day is a debate on the Kelo versus New London case, the case that the Supreme Court will be hearing oral arguments on February 22nd. And to moderate this debate is my colleague and our Associate Dean for Academic Affairs, Hiram Chodosh. So I will turn the podium over to Hiram, who will moderate our debate.
Thank you, Jonathan. Welcome, everybody, to our capstone session of a very special symposium, a debate, as Jonathan said, on the scope and limits of eminent domain. I'd like to thank Professor Jonathan Adler and Dean Reuter of the Federalist Society for putting together such a wonderful exchange. In the American legal tradition, nothing focuses our intellectual culture of dissensus like an active case or controversy. And as you know from your program, over the next 90 minutes, you will observe, participate in, and then reflect upon a debate over the Kelo case, as Jonathan said, with oral arguments scheduled later this month. The Supreme Court will decide whether the public use clause of the Fifth Amendment prohibits the exercise of eminent domain to promote economic development through increases in tax revenues or job creation. In particular, does the permissible scope of public use include the transfer of property rights to private, non-profit development corporations, and what is the role of the courts in reviewing state determinations of the scope of public use as a limit on permissible taking? Today's debate features two leading national experts on the issues presented by Kelo. On one corner, on the side of Kelo, the plaintiff, Bert Gall. To my left, a staff attorney at the Institute for Justice will argue that the exercise of eminent domain by the City of New London was unconstitutional. And in the other corner, on the side of New London, Professor Peter Byrne of Georgetown University Law Center will defend the city's position. At the Institute of Justice, Bert Gall litigates property rights, school choice, economic liberty, and other constitutional cases in both federal and state courts. For example, Mr. Gall is lead attorney in a civil rights lawsuit in New Hampshire challenging that state's law allowing government-hired inspectors to enter and search the homes of every person in the state, a law that also penalizes anyone who refuses to consent to an inspector's search. He received his law degree from Duke University in 1999, where he was an articles editor on the staff of Law and Contemporary Problems. Mr. Gall received his undergraduate degree from Rice University in 1996, where he majored in history and political science. Before joining the Institute, he spent 2 years in private practice at a large firm in Charlotte, North Carolina, where he worked on a variety of commercial litigation cases. After law school, he clerked for Judge Karen Williams of the U.S. Court of Appeals for the Fourth Circuit. Professor Peter Byrne of the Georgetown University Law Center teaches property, land use, historic preservation, and constitutional law. He graduated from Northwestern University and from the University of Virginia School of Law. He was a law clerk first to Chief Judge Frank Coffin of the U.S. Court of Appeals for the First Circuit, and then for Associate Justice Lewis Powell of the U.S. Supreme Court. He subsequently was associated with the firm of Covington and Burling. He's taught at Georgetown since 1985, and in 1996 to 97, he was the John Carroll Research Professor. He served as Associate Dean for the J.D. program from 1997 until 2000. He's currently Faculty Director of the Georgetown Environmental Law and Policy Institute. He's published numerous law journal articles, many of which analyze the application of the Constitution to land use regulation processes. He received the District of Columbia 2004 Mayor's Award for excellence in historic preservation for his role in creating a very exciting website for the study of historic preservation law. It's at www.georgetown.edu/histpress, HISTPRES. Recently, he co-authored an amicus brief for the National League of Cities in the Kelo case. We've structured our session into three distinct segments: head-to-head debate, Socratic inquiry from the audience, and reflective discussion. Accordingly, during the first half hour, in order to capture the arguments the Supreme Court is likely to hear later this month, first, each side will be given 15 minutes to present his argument. Then, in order to get the audience involved in the debate, we are deputizing each of you as justices of our public tribunal today your questions must be critically pointed toward one or the other side. And we'll take a question, for example, to Mr. Gall, who will have 2 minutes to answer, and then Mr. Byrne will have a minute to rebut. And we'll go back and forth like that for a half hour. So please make your points very pointed to one side or the other. In the last part of our session, we'll sit back from this debate format to reflect more generally on the case, the persuasiveness of the arguments you heard, the likely outcomes, and the anticipated implications for the future of eminent domain. We're happy to receive questions online. For those of you watching by webcast, please email your questions to Jonathan at jha5@case.edu. Those watching upstairs should submit your questions in writing to one of our student assistants. And all of you in this room will pose your questions with the microphone here. Well, we can hardly wait. So with the ground rules firmly in place, I turn the program over to Mr. Gall, who has 15 minutes.
Thank you. Appreciate that. I was going to launch into the beginning of this debate with kind of a sterile discussion of public use and how did we ever get to the point where a shopping center could be considered a public use. But I thought it'd be useful to frame this debate, or at least my remarks, reminding everybody that there is a real human element and often an element of real tragedy that surrounds the debate over the use of eminent domain, because we're actually talking about people's lives and being uprooted from a home of 30, 40, and in the case of Kelo, 80 years or more, and having that ripped away from you so that somebody can build a private project. And never was that driven home to me more than yesterday when I was in Norwood, Ohio, which is a city that is thoroughly completely enclosed by Cincinnati. And there I was at the home of Carl and Joy Gamble, who've lived in their house for 35 years. It's the first and only home they've ever owned. And they were moving out yesterday. And the reason they're moving out is not because they wanted to. They love their home. They love that area of town. But because a developer who happens to have his offices right across the street and a shopping center across the street wanted to build a new shopping center. Now, under Ohio law, you can't actually condemn property for economic development, so he needed a pretext. And so that pretext was to call the area blighted and deteriorating. Now, of course, the developer initiated and then paid for a study that he then gave to City Council, which said that the area was blighted and deteriorating. And by the way, if you ever find for me someone who does blight studies for a developer or city that does not find an area to be blighted, I'll be willing to give you $1 million. You're just not going to find it. I've never seen it. It just doesn't happen. It's funny how if you pay for a certain result, you're going to get that result generally. So the city of Norwood, for the benefit of this developer who wanted to put up a new crate and barrel where the Gamble's house now stands, condemned their property and said, sorry, you've got to go. And they condemned the properties of a few other homeowners and property owners in the area as well. A lot of other people in the neighborhood wanted to sell. The developer was offering a lot of money, but the Gambles wanted to stay. This was the place where they were going to live. We've been fighting this court battle now for a long time, and at the trial court, the trial court threw out this whole preposterous notion that the area was blighted. The blight study is actually, I invite anybody to read it who wants a good laugh at one time and designate an area as blighted, but the trial court allowed the condemnations to go forth on the theory that the area was deteriorating. And I have to worry all of you that if you live in Ohio, and I know many of you do, that your homes are probably deteriorating because under the trial court's definition, something called diversity, or in the city's definition, something called diversity of ownership allows an area to be blighted. And you know what that means? Basically, in a neighborhood, more than one person owns homes in the neighborhood. That's right. What neighborhood do you know of where all the homes are owned by one person? You just don't see that. In other words, the definition was so broad as to encompass every single neighborhood in that city and probably throughout Ohio and the United States, and was a total pretext. And what it was a pretext for was a taking for economic development. And that brings us back to Kelo and the whole issue of does economic development raw economic development, not with the pretext thrown in of blight removal or slum removal or even deteriorating conditions removal, does that constitute a public use under the Fifth Amendment to the United States Constitution? And should we allow condemnations for the benefit of economic development? Well, I submit to you that the answer to that question, used to be a relatively easy and straightforward one. It still should be, but it certainly used to be. I mean, with minor exceptions, and I know Professor Byrne will argue with me on this, but up until about 1950 or so, layman's understanding, court's understanding, everyone's understanding generally was that a public use was literally something that the public would own and use, like a road or a bridge or a necessary public building. It could also include, certain utilities and railway easements and canals, things of that nature. That's what a public use was generally considered to be. But then in 1954, there was a Supreme Court case of Berman versus Parker that took place in the urban renewal setting. And in Berman versus Parker actually involved an area of southwest D.C. that was a real slum area. I mean, if you look at some of the statistics from the district court opinion there, I believe that the crime rates, the infant mortality rates, the death rates, they were 6 to 10 times higher than anywhere else in the city. We're talking not having electrical wiring. We're talking not having plumbing. This was a real slum area. And the Supreme Court, with a sleight of hand, said that taking the property in the area would be a legitimate public purpose. Didn't say use, said public purpose. The very act of removing, the slum area would accrue such benefit to the public that it should survive scrutiny under the Fifth Amendment. Kelo is not about urban renewal. It's not about removing slum or blighted properties, but it's important to understand Berman because it was the beginning of a slippery slope that we have now pretty much reached the bottom of. Because as soon as an exception was opened up, municipalities rushed to take advantage of it. And now you see municipalities and cities across the country. First, there was the idea of condemnation for slums. Then the idea of condemnation of blighted areas, not quite as bad as a slum, but supposedly getting there. And now you see this idea that you can condemn, deteriorating properties, not as bad as a blighted area. And of course, at the very end of the slippery slope is the idea that you can condemn an area not because there's anything wrong with it, not because the homes are bad, there's any danger to the residents who live there or danger to the surrounding community at all, but because you need to create more jobs and increase the tax base, increase social services. That's the reason that you have to condemn this land, and that's where we are in Kelo. So hopefully, there was a brief 200+ year history of where we are in public use. Skipping over a lot of the details, obviously. Now in Kelo, you have a situation where there are several homeowners who live in the historic Fort Trumbull neighborhood, and Wilhelmina Derry has lived in that neighborhood since 1918. She was born in that house and intends to live the rest of her life in that house. The same for many of the other homeowners whose families go back for generations there. Pfizer wanted to build a global research facility in New London, but as a condition of moving in, they wanted the town upgraded. And by upgraded, they meant, let's get rid of this middle class, it's okay housing, it's historic and all that stuff, but what we need is office space and a high-tech office space, and it would be nice to have a luxury hotel maybe, and it would be nice to have upscale housing for our executives and new office space for our contractors. So you're going to need to take care of all that and get rid of that mess. And so that's exactly what the city of New London proceeded to do. In fact, New London New London had created a while ago a private nonprofit corporation called the New London Development Corporation. The New London, and it delegated to the new NLDC its power of eminent domain. And the NLDC then proceeded to condemn, or at least designate as a project area. I believe, I think it's about 99 acres, although I could be mistaken in that number, but a large area, and proceeded to condemn it. Our clients live in 2 very small parcels in that whole area. In fact, if you added up the amount of land that their homes occupy, it's like 1 point something acres, just a very, very small amount of land of the whole project. And they did not want to leave. In their project, in these 2 parcels, and this is kind of one thing that's important to keep in mind for the facts of the case, the City of New London and the developer who was going to develop all this wasn't even exactly sure what he's going to do with the property when he gets it. One parcel, parcel 3, is designated for office space, but the developer, along with a lot of experts who testified at the case, said, well, we're not even sure if we can, if there's going to be a market for office space in the future. So we don't really know. Maybe, but we'll have to wait and see. We're just not sure. Maybe never. The other area where most of our clients live, parcel 4A, was one where the City of New London and New London Development Corporation, the developer, have absolutely no idea what's going to go there. I mean, they have postulated a number of different theories as to what they might choose to put there, but they have no idea. So the question should be raised then: if a city doesn't know what it's going to do with the property, if it doesn't even know what the use is, then how is that a public use? Well, it's a good question, and I hope the Supreme Court answers it here. But more generally, economic development standing alone cannot be a public use under the Fifth Amendment. And the answer to that, and why that is so, is simple. The Constitution says property can only be taken for a public use. That posits the existence of something called a private use, a use that is forbidden, a use for the benefit of private parties. If economic development is allowed to be a rationale that will be accepted across the board for the use of eminent domain, then how do we tell the difference between a public use and a private use? Because the justification of all economic development takings is that their benefits will trickle down to the community, that we'll see over time new jobs and new taxes created. Well, under that rationale, just about everyone's home or business could be taken by eminent domain. And there really is no limiting principle here, because under the Connecticut Supreme Court's rationale, the Connecticut Supreme Court's decision, all that a municipality has to show in order to demonstrate that it is taking property for a public use is that it has an intent that the taking will produce a public use. That's it, an intent. Somewhere on a piece of paper that we intend that these benefits will trickle down somewhere. Well, how do you enforce stopping a private use under that standard, which amounts to absolutely no standard at all? It basically says anything goes. If there is a claim that this taking for the benefit of a private developer or some other business will produce more jobs and will produce more taxes, that's it. That's the ball game. This taking is justified. And courts, under that standard just aren't going to be able to tell the difference. Before the Supreme Court, we have advocated a Brightline rule and just say, look, economic development is not a public use. It just doesn't hold up. But at the very least, the Supreme Court and courts around the country, and many courts around the country are doing this on the state level, need to actually take a hard look and apply real scrutiny to takings that involve transfers from one private entity to another private entity. And at least one step in that direction would be to make sure that there is at least some reasonable certainty that the proposed benefits will actually accrue in time. In New London, there's no guarantee of that whatsoever because the city has no idea and the developer has no idea what he intends to build in the area. Across the country, between 1998 and 2002, there were over 10,000 examples of transfers of private property from one owner to another or threatened transfers. That is a lot. It probably is a figure that underestimates exactly what's going on in the country because no states keep a hard and fast look at what goes on. But it tells you that, yes, municipalities are abusing the power of eminent domain, and that, yes, in many states, New York, for example, or Kansas, for example, anything goes when it comes to condemnations. Private use condemnations are allowed. And for that reason, it's time for the Supreme Court to step in and say, this far and no further. The Fifth Amendment provides a baseline of protection to all citizens. And it says, your property shall not be taken for public use. It's not a hard concept to understand. We hope that the court, will come around to that, or at least, at the very least, start applying some real objective standards so that private use condemnations won't continue to run amok, and so that people like the Gambles and Suzette Kelo and Wilhelmina Dairy will not be driven from their homes from somebody else's private benefit. So, thanks. I see my time has expired.
Well, it's a pleasure to be here today and have a chance to talk with you about the Kelo case. Debate is not my natural mode of addressing issues. When I was young, I was reasonably good appellate advocate, but I have decayed into a wishy-washy professor for the most part. Although hearing Bert's remarks does sort of stir some atavistic juices.
Good. That was their intent.
I think it's worthwhile noting that Bert began his presentation by talking about a different case than Kelo. I think that, and I don't know anything about the case he described, but I think that one of the issues here is, why are we talking about this case of eminent domain rather than some other one in which the public process, the public purpose might be less clear than it is in this case. I want to tell you a little bit about the background to how this eminent domain came about before I launch into some sort of broader statements about the law. Bert suggested that the decision to use eminent domain here was done, as it were, at the behest of the Pfizer Corporation, that it was in some sense inconvenienced or found the local middle-income people tedious and therefore wanted to remove them so that executives would have a more pleasant environment in which to live. Well, that may be his view of the facts, but it has nothing to do with the facts as found by the trial court or any of the facts as recited by any of the justices in the Connecticut Supreme Court. What you have here, in fact, is an effort by a seriously declining municipality, a very old city, that has lost a great number of manufacturing jobs, that has lost population. The population declined by about a third from 1960 to the present, and that in the 1990s lost a very significant submarine base, which had been the cornerstone of the community's identity and economy. When Pfizer came in, it created an opportunity that between the Pfizer research facility and land obtained from the Navy as a result of the base closing, they saw a possibility for redevelopment and to try to attract new businesses so as to provide jobs for their people and tax base for the local economy. They followed a very elaborate process here. There was a long-term planning process that went on for years. Early on, there was notice given of different possibilities. There were many public hearings, environmental impact statements. There were approvals by various levels of state government of the plan, with the understanding that eminent domain would be used. And there were express approvals of the plan and of the use of eminent domain by the City Council of New London. So this is not something that happened in the dark. It's not something that happened outside of the course of state law. It was something that the community had a long time to assess in light of a plan to use the land for particular purposes of urban redevelopment, and in which it was approved. Now, as such, it is there is no individual private entity that stands to make a bundle out of this. The Development Corporation that's sometimes alluded to, the London Development Corporation, is a creature of statute. It is a nonprofit entity that acts as the agent of the City of New London. And when the land that's acquired either by consensual purchase or by eminent domain is actually taken by this agent and is held in the name of the city. And the intent is then to, in a development project, to lease the land out to developers for projects that meet the plan. That's what's on the table. That's what's on the table in this case. Now, this project greatly resembles many projects that have gone on over the past. It largely resembles the project in Berman versus Parker, and I want to talk a little bit about Berman versus Parker in a minute. But Bert made the claim that before Berman versus Parker, there was a consensus as to what the public use requirement of the Fifth Amendment meant, and that it meant that the public had to own or at least in fact use the property. But the fact of the matter is that that's not true, certainly as far as the U.S. Supreme Court goes. How many cases do you think are there in which the Supreme Court has found that a state or local exercise of eminent domain violates the Public Use Clause in the history of the United States? None. Not one. And there are cases going back, as Tom Merrill described a little bit this morning, back to the 1890s, in which land was taken by states or localities through eminent domain and was given to private parties in order to advance economic development. Those are cases involving access to natural resources. They are irrigation canals in Utah. There are sort of wire apparatuses across somebody's land for mining, a number of such things. But the fact of the matter is that there's never been a case in which the Supreme Court has reversed a state Supreme Court decision that an exercise of eminent domain violates the Public Use Clause. There's one case in which there was found to be a violation of due process when an order was given, but there was no exercise of eminent domain and no compensation paid. So what the petitioners are trying to do in this case is to get the Supreme Court to, for the first time, inhibit what states and localities can do in regards to the exercise of eminent domain. Now, let me say a little bit about the current precedents, Berman versus Parker and its subsequent precedents. Berman versus Parker was a unanimous decision of the Supreme Court 50 years ago, in which they basically said that eminent domain is a legislative power and that it is constrained to the same extent as all other legislative powers, but if just compensation is paid, no more. In other words, that the objects for which eminent domain can be used are as broad and as open as the objectives that can be pursued through other forms of legislation. And that makes sense. It is completely consistent with the language and the history of the Fifth Amendment. Nor shall property be used for public use without just compensation. The language for public use there is a synonym for eminent domain. The intent of the framers was to distinguish the exercise of eminent domain from where compensation must be paid from other circumstances in which the government would take property but not pay compensation. What's an example of that? It would be a forfeiture of property, for example, by somebody who engaged in treason. Today, the government can take a car that's used in a drug violation, and of course they don't have to pay compensation. That wouldn't be a taking, that's not an exercise of eminent domain. The government doesn't have to pay compensation. When they take your property through taxation, which is not eminent domain, of course they don't pay you compensation. But that's normal. So what, in fact, is it? If just compensation is the only limitation on eminent domain, what does limit it? What limits it is essentially the standards of the Due Process Clause, the basic the basic standard that all exercises of legislation must advance or be reasonably understood to advance legitimate government purpose, same as any legislation. And of course, there are the other limitations of the Bill of Rights, for example, the Equal Protection Clause and other kinds of protections. And the court adopted that unanimously in Berman versus Parker. They unanimously affirmed it in even stronger language in the Midkiff case in 1984. And subsequent to that, in two other cases, they have followed those precepts and applied them without any justice of the court expressing even a whisper of discontent or dissent. So what we're dealing with here are enormously well-entrenched precedents that have guided the use of eminent domain throughout, we'll just say throughout the 20th century. Okay. Now, it certainly is the case that a number of state Supreme Courts have demanded more, that they have put higher standards or different standards on the exercise of eminent domain by state government or by their local governments. And this has been a feature of American jurisprudence since the 1830s. The Supreme Court has taken account of this on numerous occasions, and they have said very expressly in cases going back to the 1890s that this is appropriate, that the question of the usefulness of eminent domain or its role in the government structure of a state will depend to a large extent on local conditions, on differences among the economic situations of the state, the physical circumstances of the state. And they said this in particular in regards to Western states that use eminent domain across private land for irrigation ditches, which predominantly benefit other private farmers. And the view of the Supreme Court is, well, we're not sitting in Utah. We know it's very dry there, and we defer to their view that this is an appropriate kind of role for government in an arid state. Well, such a rule in Connecticut might well be would be foolhardy. There's plenty of water in Connecticut, but what there are a large number of small cities that are economically depressed, that were built up at a time when a very different economy pertained, and in which you have a lot of small land holdings that would frustrate an attempt to try to develop them in accord with modern economic needs. You have shrinking tax bases, and you have all the problems that Tom Reed described of movement to easier to work with suburban locations. So one of the things that is troubling about the request to have the Supreme Court decide this and to impose a very narrow view of what a public use would be is that it would subject all the states of the nation to one restrictive standard. And that's unfortunate because of the diversity that we see. Well, what about, I think that the strongest argument for the position that Bert is advocating is the concern that we would all share about unfairness to individuals. The sense of, for example, as described, someone who's lived in their house for a very long time and has understandable social and emotional attachments to the house, and to the extent of which what they're going to lose. Now, I would point out that two of Bert's clients are absentee landlords who hold their land for investment purposes, so they're not all widows and orphans. But the one thing to be said, well, a number of things to be said, but the first thing to be said about that is that they are entitled to what the Constitution promises them, which is just compensation, which is the market value of their land. Now, that's not a complete answer, and I would be the first to say that, because the market value of someone's land who doesn't want to sell doesn't reflect the value that it has to them. That's why they don't want to sell at that rate. But the fact of the matter is that, well, a number of facts of the matter. In Kelo, and in most cases, there is compensation paid to the owners above and beyond what the Constitution requires. Connecticut is one of the states that follows the Uniform Relocation Assistance Act, and they will pay to all the people displaced from the redevelopment area $10 million in compensation above what the Constitution requires. Is that adequate? I don't know. I mean, in other words, adequate in the sense of justice. Perhaps people should take a closer look at this. I've advocated in a piece that homeowners should get something in excess, just a 10% or in excess of market value as a way to provide damages for the personal losses that they suffer. Historically, the Supreme Court's been very resistant to that because of the difficulty of assessing in any individual case what it is that an individual lost. But here's a more fundamental point. Restricting the scope of public use is completely unresponsive to that aspect of loss that the people suffer, because they would not get paid any more if what the city or state was building was something that we would all recognize as a public use, like a highway. And why do you build a highway? You build a highway for economic development. So that so long as the government is building something which will be owned by the public and is sort of familiar, more familiar as a type of eminent domain project, the property owners would have no constitutional claim at all. But they still would suffer. They still would suffer in essentially the same way. My time's up, but I'd be happy to go further into any of this or some other aspects during our question and answer session. Thank you.
Thank you very much, gentlemen. I'd like to now invite some questions from the audience. If you could, please direct the first question toward Mr. Gall. Yes.
Mr. Gall, this may be a two-part question, but let me begin with the first part.
Sure.
Would you advocate as a Brightline rule, a rule that would include the third step that the Kelo dissenters called for? And perhaps you might be able to state that better, but it goes to the reasonable certainty issue that you were discussing. That's the first part.
Okay, well, I mean, two parts to a two-part response to the first part of your question, which is first, yeah. I mean, first there should be a Brightline rule because, contrary to what Professor Byrne says, the public use clause is an actual limitation. I mean, the Supreme Court has stated even in Midkiff that takings for a purely private use would be forbidden. So that tells us that the public use clause means something over and above just compensation. To suggest otherwise is inconsistent with Supreme Court precedent. But if we're going to reach that level of saying that economic development can be a public use, then yes, some standard like the dissenters in the Connecticut Supreme Court talked about would be useful, whereas there is some reasonable certainty that the project is going to produce the intended benefits. With a taking that is for a true public use, the benefits are accrued almost instantly. There's a bridge, there's a road, there's a canal, or in slum removal cases or blight removal cases, the blight is eradicated. But in Kelo, the benefits will occur, if at all, years and years down the line, and there's no real certainty that they'll ever accrue, particularly because the New London Development Corporation, the developer, doesn't even know what they're going to do with the land. So at least providing some sort of objective standard beyond letting the Supreme Council kind of pass the stupid staff test that the Supreme Court talked about in Lucas would at least be needed to guarantee that municipalities are not engaging in the kinds of abuses that they do. So that's a long-winded answer to your first part.
The second part to follow up on that is that my reading of that third step essentially renders the local government or the state government a guarantor of the economic profitability of the project. And by doing so, essentially is a test that is fatal in fact, if not on its face. And do you agree with that, and or do you see that differently? Do you see it as not fatal in fact?
No, absolutely not. It doesn't involve people being a guarantor, but it actually involves taking some actual reasonable steps to make that benefits will accrue. And all that a court would have to do, I mean, we're not asking courts to, under that standard, to say, is this a good plan or is this a bad plan? But what courts are looking at instead is, has the municipality put in place some guarantees? We're talking about contractual terms. I mean, something like that would at least say in 5 years or at any point in time, is this going to actually produce some real benefits down the line? I mean, let's actually see if there are some actual guarantees. But what you can't have is allowing municipalities to write a blank check, to a developer. I mean, the New London case is a perfect example because there the developer essentially has a blank check. He doesn't know what he's going to do with the property. He may not build office space for 10 years. He doesn't know what he's going to build in Parcel 4A at all. So here we've got land that's just been handed over. We have no idea what's going to happen with it, if any benefits are ever going to accrue. So yeah, that test would be fatal in that situation. But in other less extreme situations where the municipality has actually done some work and done some responsible staff work and not employed a stupid staff, the test could be passed.
I'm going to give Professor Byrne 2 minutes to respond.
First of all, the notion of private use. This is correct. That if one would show that use of eminent domain was strictly to benefit a private entity, it would be unconstitutional. And I agree with Bert. The Supreme Court would say that violates the public use clause. But the fact of the matter is, the Supreme Court has said repeatedly that the public use standard is coterminous with the police power under the Due Process Clause. And the fact of the matter is that any legislation, regulatory legislation, that was designed simply to favor a private party and had no public benefit would also be unconstitutional. So those are really the same. Now, the question of what kind of showing a city would have to make here, I think, is really quite odd. New London here has gone through a great deal of political turmoil, and they've put up, I don't know, $100 million banking on the fact that this project is going to be successful. It is a very conspicuous project. If this project fails, the city is going to be in bad shape, worse shape, and the politicians will suffer the fate of the Lakewood politicians, I'm sure, perhaps worse. I think that a regulatory agency of the responsibility level of the City of New London, the New London Development Corporation, that's putting up public money, putting their prestige on the line, is a much more trustworthy predictor of the success of a redevelopment project than a federal judge who has absolutely nothing at stake. And, they're just not all that much more clever than we are. What they get through litigation is what they get through litigation. So I don't think that's helpful. And I think it also would create a great deal of doubt ex ante as to whether anything would go through and would act as a substantial damper on use of eminent domain in circumstances where it would otherwise be justified.
Yes.
This is for Professor Byrne. Let's assume that there's a community with a big box retailer that's the community's largest employer and a key to its redevelopment efforts. The big box retailer asks the city to condemn the parcel of a direct competitor for retransfer to it, proffering a blight study and citing the generalized wording of the local statute that there can be eminent domain to revitalize the community. The city goes ahead and makes the condemnation. The state court determines, number one, there is no blight, that was simply pretextual, but that the city officials, in good faith and reasonably, determined that assuaging the concerns of the big box retailer would in fact result in more economic revitalization in the city. Is that permissible?
I think it is permissible under the federal Constitution. I think that it is a troubling case, and I think that let me take the two sides of that. I think that what is troubling about that is that in the context you described, there's no planning, there's no independent determination of public benefit. It is a very shoddy way to proceed, and it's bad government. There are lots of remedies for bad government other than creating a large constitutional rule to prevent lots of exercises of good government. It seems to me that part of the problem there might be with the state statute in terms of allowing planning to occur without more process and without more without even substantive limitations on what they can do. But it's I don't think it ought to be unconstitutional under the federal Constitution.
I'm baffled by that response because first, I'm to understand that the Constitution does forbid private uses, as you've just talked about, but this is clearly an example of a private use. The city of the 99 cents versus Lancaster case that you're talking about out of the Central District of California, it's clearly one of the worst examples of a private use condemnation. So the Constitution either imposes a limit of private use or it doesn't impose a limit of private use. And the answer is that it does. Look, we don't talk this way about our other rights. We don't talk this way about our First Amendment rights or our Fourth Amendment rights. We don't say that, well, let's let the community get together and decide which topics we're going to allow to be discussed because we can trust the legislative process to make sure that, we're not going to interfere with people's rights. And we don't need courts stepping in and saying that this speech is okay because, well, this might violate our, violate our community standards of what political speech we like and which speech we don't like. The same with the Fourth Amendment. We don't say, okay, there's no need to have this limit on search and seizure. I mean, come on, it's perverse to impose that kind of standard across the board. Let's let our responsible community leaders decide what's a reasonable search or not. We don't do that with other rights. And if we're going to concede that there's a limitation with the Fifth Amendment, courts are going to have to step in and protect it, just as they do with other rights.
Next question from Mr. Gall. Is there a question from? Yes. If you just pause for the microphone.
Thank you. You mentioned that a portion of the parcels in the development area had no specific prescribed use. So was there a development plan adopted by the community? And the second part of my question was, had they identified end users for all the property? Would have that satisfied your needs?
Well, there was a plan, and like I said, for part of the area, one parcel where some of our clients live, the plan was office space, but it was office space maybe along the line sometimes if we ever get to it. And the developer, Corcoran Jennison, who the land was going to be leased to from the NLDC, never, he said at the time office space just wasn't feasible there, just flat out. In the second parcel, parcel 4A, the City of New London defined that as park support, but none of the city's witnesses or the NLDC's witnesses or the developer's witnesses could ever identify what exactly park support meant. They were all over the board with that. So there was absolutely no idea what it meant. So at the very least, you should have some idea. I mean, we're not asking for a very high bar to jump over here to take somebody's home. At least know what the heck you're going to do with it when you achieve it.
So if private businesses were ready to occupy all that property, you would be okay?
No. I mean, look. I'm being perfectly consistent. No, I'm being perfectly consistent here. I'm saying, look, there should be a bright line here that prevents economic development from being a public use. But what I'm saying is, if you're going to accept that economic development is a public use, there needs to be some sort of intermediate scrutiny that is above and beyond, what we have in many cases, which is no scrutiny whatsoever, which is what the Connecticut Supreme Court applied. So I'm not saying, we have, and I'm not saying, look, there has to be this many contracts or this many people lined up, but at the very least, because these condemnations produce attenuated benefits down the line, we at least need to have a reasonable certainty that actual benefits will be increased. The better rule by far is that economic development does not constitute a public use. It's a Brightline rule. It will not cause the heavens to fall because as you look across the landscape, you see states where there is a Brightline rule that this is not allowed, and they do just fine. I mean, they didn't submit amicus brief saying, do this or the heavens will fall. They're fine. Michigan realized they screwed up in the Poletown case and reversed that. Maine, Washington State, Florida, Illinois, other cases, other states say don't do it. Development happens there all the time. So there should never, the ends never justify the means when it comes to violating constitutional rights. But here, there's no actual practical need to do just that. So, but yes, the Brightline rule is the better rule because you need to protect against private use condemnations. And the fact of the matter is, on the ground, when you look at these projects, developers approach cities and say, give us that land, so that we can, build our store. And if you'll condemn it for us, it'll save us on acquisition cost. We'll get all sorts of tax breaks. It'll reduce our risk. You'll get increased jobs and you'll get increased taxes. These deals are often made in the back room. But even when they're done in open fashion, it's still wrong because minorities, people who are just underrepresented politically, they're often the targets of eminent domain abuse, and they're the ones that are going to get squeezed. So I've run Ray over so you can have some extra time for that.
But that's not our case here because this case doesn't involve any minorities, doesn't involve anybody of any unpopular political persuasion. There's nothing like that. There's not a backroom deal. This was done according to a plan. Under Connecticut state law, they can employ eminent domain in these kind of circumstances only pursuant to a detailed plan that is approved by several state agencies and by the New London City Council, and that's what you have here. Now, will this plan work out? I don't know. I can't say. But I do know that New London has put an enormous amount of money and effort behind it, and they've satisfied the experts within their own state government.
A question for Professor Byrne. Yes, Jonathan?
We have a question from a viewer of the webcast.
Great.
And the question is asking about the two properties. There are two properties in question, I presume, in the neighborhood that are to be controlled privately in the development plan, an Italian Dramatic Club and a marina. Why is their situation different from Suzette Kelo's, and is this a violation of the 14th Amendment? I assume the questioner means is there either a cause for greater scrutiny or perhaps an equal protection problem, given that it appears that the City of New London may have played favorites with these two properties?
This was litigated in the state courts as to whether that there was a violation of equal protection or some undue discrimination in the decision by the New London Development Corporation not to take particular properties. And I don't know a great deal about that, except that the Connecticut Supreme Court, nobody on the Connecticut Supreme Court thought that there was a violation of law in that. My understanding is that the Italian Social Club is on the perimeter of the development area, and was essentially optional as to whether to include it or not, and they didn't include it.
Well, it turns out that the Italian Dramatic Club is a favorite hangout for New London politicians, and they're members of it. So why do you think they would want to condemn their own Italian Dramatic Club? It makes absolutely no sense. And it tells you what goes on in these cases all the time. If you've got influence, like those politicians obviously do, you're not going to allow your property to be condemned. So there is practical discrimination that goes on. If you've got the influence, you can use that to make sure that your rights won't be violated. But if you don't, if you're just an average, ordinary person who doesn't have that kind of influence, your properties will be condemned. And speaking of the property areas that we're talking about in New London, the parcels 3 and 4A, they are such a small percentage of the total project land area. And the City of New London has absolutely no idea, once again, no idea what they're going to do with them. There is no reason that they cannot build most of that project right now. Not just most of it, the vast majority of it right now. But they've been obstinate, insisted, we need every last bit of it. But we don't need where our politicians hang out.
Is there a question for Mr. Gall? Yes, Kathy.
Mr. Gall? Two questions. I was going to ask Mr. Byrne one, but I'll start with Mr. Gall. Part of what's happening here, I think, is that there are two different views of what property rights are here. We're talking about taking private property for public use. And Mr. Gall's focus is on the fact that people's property is being taken, which I think is the people get to keep their property view. And perhaps Mr. Byrne's view is that private property is conditioned by the Constitution on an ability to take it for public use. So I guess that would be my question. I have to ask Mr. Gall, and that would be my question for him, which is your conception of what private property rights are in this context, in terms of the ability of people to keep their property in the face of government action.
Sure. I mean, the Fifth Amendment provides two discrete protections for owners of property. The first, that everyone talks about, that you hear about all the time, is the just compensation clause. But the one that you don't hear people talk about enough is the public use clause. And that means that the power of eminent domain can't be used to take your property and give it to another private person who wants it for his private benefit. And that's not some radical conception of the law. I mean, the Supreme Court has stated it many times. Have they applied it enough? No, but they've made that principle loud and clear, that it is a limitation on the ability of somebody to take your property, to take it for someone else's private use. I think Professor Byrne had remarked earlier about there's a tragedy, just as much of a tragedy. If tragedy, I think you would put that in quotes maybe, but when it comes to taking somebody's property for a highway or a road, as there is for taking it for a shopping center or something like that. Well, that's not the point. I mean, the founding fathers understood that eminent domain was an awesome power and it should only be used in certain situations. I mean, the Supreme Court very early on referred to eminent domain as the despotic power. And there was this idea that we're not going to be like England, where the king can use eminent domain anytime he wants to take any property that he wants. We don't have a king anymore, and so what we're going to do is make sure that our government can only take property in certain discrete situations, public use situations. That's it. So yeah, it's a terrible thing, that's gonna happen. So let's make sure it only happens in a small category of cases. But if we're not in that category of actual public use, then my right to my property is inviolate. Professor?
I think that there's no indication at all that the founders were concerned about the distinction between taking of land for shopping centers and for highways. The fact of the matter is there's no indication that they were concerned at all about the scope of the uses that eminent domain could be put to. That was not a debate that was in any sense lively at that time. What they do seem to have been concerned about was that the power of eminent domain be exercised under legislative control rather than by a king, by an executive. And that's what we have in all these cases. And what I'm arguing for is a standard of constraint that's appropriate to legislative. I love the institution of private property. My life is devoted to teaching property law. But I think property law is a complex institution that relies upon the consent of society as a whole to observe and safeguard the private rights that are allocated to individuals. And it doesn't seem to me to be at all troublesome in a general proposition to say that the rights that we have to property depend upon society, and that society's right of eminent domain is an appropriate limitation on those rights.
Yes.
First of all, the founding fathers were founding a constitution only for the federal government. The states, of course, were separately governed by their own people. And a state, Ohio, has a provision in its constitution that economic development is a valid public purpose, and the cities are authorized to implement that particular provision. And judging from what Professor Byrne has said, Connecticut has similar legislation. Does this not then create a public use for purposes of this case?
Absolutely not. First of all, that provision in the Ohio Constitution that you're talking about, I heard about that a lot in the Lakewood case. I heard about it a lot in the Norwood case, but I've also seen no one actually seriously advance the argument that it really provides the justification for an actual public use. I mean that argument.
In the Lakewood case.
Well, you were wrong. To be blunt. But I'm talking. Having actually litigated the case and been familiar with some of the documents, I can assure you some of the arguments that were made, and the city certainly wasn't. I mean, I'm sure they would have gotten around to being more forceful about that argument eventually, but they were relying on a couple of other things. But no, I mean, look, a state can't degrade the amount of rights that are available to their citizens pursuant to the Fifth Amendment as applied to the states through the 14th Amendment. I mean, I find it remarkable that we can have this discussion and say states can reduce rights and just pass on that in the context of property rights. But can you imagine us having that discussion in the context of the First Amendment or the Fourth Amendment or any other amendment where we said it's up to society to protect those rights and it's up to the states to determine how that must be done? I mean, can you imagine us doing that in any other situation? Ohio says that a reasonable search and seizure occurs anytime we find out that you've bought the latest Britney Spears tape because we accuse you of having bad taste. That's a reasonable search and seizure. So
we're talking public use, and if the state determines there's a public use, why would the Supreme Court of the United States say there is not?
Because you can't call an apple an orange and pretend that you're telling the truth. I mean, you can't do that. No more than the state of Ohio could say under free speech, under the First Amendment, you not saying anything against the governor, is okay under the First Amendment. You can't do that. I mean, if it's true for one amendment, you've got to take it for every other right that we have.
Professor Byrne.
First of all, of course, we're not talking here about reducing any federal right. There's not one thing we've pointed out here is that there's no that the kind of protections that Bert's advocating for have never been recognized by the Supreme Court in any holding. Never held that way. And so what we're talking about is extending federal constitutional protection to property owners. Now, going to states have a great variety of the ways in which they write public use limitations into their constitution. Some specifically list what public uses are. As you say, Ohio has economic development. Many of the states in the West specifically indicate that, for example, the taking of land for irrigation, for farms, and for mining uses is a public use under our Constitution. Other states have things which some states say more restrictive rules that such and such can't be a public use. So our history is a great deal of diversity among the states and approaches to public use, and the Supreme Court has developed its doctrine in the light of that, and with the understanding that many states, either because of the way their constitutions are written or the way their state Supreme Courts have interpreted it, choose to have a more restrictive rule.
Well, can I respond to that? First of all, the United States Supreme Court has decided 2 eminent domain cases in the last 50 years of real significance, Berman versus Parker and Hawaii versus Midkiff. Berman versus Parker, Professor Byrne accused me of not talking about the relevant case. Well, Berman versus Parker is not the relevant case to be applied here because Berman versus Parker is about slum and blight clearance. That is the justification for the takings in Berman versus Parker. The Supreme Court can rule against the use of economic development in Kelo without overturning Berman versus Parker. So that is not the relevant case. The same with Hawaii versus Midkiff, which involved eliminating an oligopoly of land ownership that existed in the islands that dates back to Hawaii being a kingdom. The United States Supreme Court has never said at any time that economic development is a public use, and it has intimated that in not a single ruling across the board. But it has said, and it cannot be denied, and it has not been established that the public use clause I mean, the public use clause is most certainly a limit on the exercise of power. And for that reason, what we're asking for is not any radical extension of the law. It's exactly what the Supreme Court has talked about in terms of making sure that private use condemnations don't, in fact, occur.
Well, subsequent to those two cases, too, the Supreme Court has held that the federal government can take a railroad track from one railroad and give it to another railroad because it will result in better service. And they said in that context that the public use power is coterminous with the regulatory power, even if it results in the transfer of ownership from one private party to another. 1992. And in 2003, they said the government can condemn property for any purpose that would justify the imposition of a tax in Brown versus Legal Foundation. So this is a very consistent view, and I agree with Bert that they have never expressly dealt with economic redevelopment as such. Berman is very close, though, because although that was a slum case, the claim of the property owners in that case was founded upon the fact, which was found by the lower court, that their property wasn't blighted or slum property. So what they were complaining about was being included with slum property when they weren't slum property. You didn't need to remove their property to get rid of slum property. So it really is an economic redevelopment case, and if you know about the history of Southwest Washington, it became largely a development of luxury apartments.
Now, I respectfully disagree. Berman involves the taking of slum and blighted property, and there's a general rule in urban renewal cases that you don't have to be cookie cutter in your approach. You know, if there's one nice piece of property in the middle of a bunch of blighted or slum properties, you can take all of that. But the justification, and it's clear under the holding, was that this was indeed a slum area. Connecticut had its choice, if it really thought, or New London had its choice, because Connecticut has an urban renewal statute that deals with slum and blighted properties. It didn't label that area as slum or blighted because it was being honest. It knew that there was absolutely nothing wrong with those properties except that it wasn't producing the number of taxes and jobs that it created. So Berman has absolutely no bearing on this case. It is not even remotely like the Kelo case.
As you can see, we're transitioning into our open, less formal format. So we're going to embrace the chaos that will follow. Yes.
Mr. Gall, you've intimated that it would be impermissible. Mr. Gall, you've intimated that it would be impermissible for different states to have different substantive rules about public use because the Supreme Court should interpret property rights uniformly. But how do you square that with the Pruneyard Shopping Center case, where the Supreme Court said that even though there was no right to expression in private shopping centers under the federal Constitution, nevertheless, it was constitutionally permissible for individual states to impose such requirements?
Sure. Well, look, states are always free to require a greater level of protection of constitutional rights than is the federal government. No, states are always. I mean, I'm sorry. I'm going to have to. Do I have to invoke Brennan and the upwards ratchet here of constitutional rights? If I have to, I'll do that. But certainly that is permissible. But they cannot go beneath a certain baseline.
I'm sorry. Perhaps you misunderstood my question. No one is talking about giving affirmative rights to people to speak. We're talking about impositions on shopping centers to have speakers speak on their premises, which is a subtraction from rights.
Well, I mean, fine. I mean, look at the case. Look at the case however you want to. I mean, from whatever perspective. Yes. I mean, any ruling that would require or that would allow states to go beneath any level of protection that the federal Constitution provides, I think, is wrong. I mean, however you want to interpret that.
Jonathan.
Yes, I do.
Is there a question for Peter? Is if we agree that a private use is out of bounds, what is a private use? And if the analog is the analog we see in economic regulation, where it can't be used primarily for a private party's benefit, is that essentially saying, as long as the legislature gives us some justification, which under some conceivable set of facts or alternate realities could be true, then the courts should just assume that's a rational basis and or in this case, a rational explanation of a account of how it's a public use and leave it alone.
Well, I think that the same I think there's a problem that you're identifying, and I think it's a problem that's as true of eminent domain as it is of ordinary legislation, which is what is the baseline for rational basis review. And this is a subject that has been a large and long-standing issue in American constitutional law as to whether it is strictly a nominal standard and that there'll never be a case in which courts will find the absence of a legitimate public purpose or not. My personal view is that it's slightly higher than that, but not very high. I do think, and I think this is an area where Bert and I would sort of starkly diverge. Not that we haven't already, but
I haven't noticed that.
I don't think of property as a constitutional right on the same level as the right of free speech. The Constitution expressly says that Congress shall make no law abridging the freedom of speech. That's pretty explicit. What property is a state law created interest, and the Constitution extends certain kinds of protection to it through the Due Process Clause and through the Takings Clause, and those have to be interpreted and applied fairly and properly. But I don't think it's a constitutional right in which my ability to use I can speak in a way that can hurt people, but I can't. But I shouldn't be. I don't have a legal right to use my property in a way that hurts people.
Can I just follow up on that, just to make Jonathan's question a little bit more pointed? It's hard to conceive, putting aside the standard of review, hard to conceive a private use that is not, if beneficial, is not going to produce greater tax revenues and arguably more jobs. So even a primarily private use is easily rhetorically transformed into a public purpose. So I think the question is, in your own view, putting aside what you think the standard of review should be, is there any traction?
Yes.
And where is that traction aside from the process points that you mentioned before in terms of what goes into planning? Because I think we all understand that planning process can be very result oriented.
Right. I think a case might be, the taking of property in order to give it to the wastrel son of the mayor of the city as a place to meet his mistress. Something that is strictly for the private interest of people who are political insiders is not a public purpose. That's one I would say. Now, as I ratchet up from that, you do reach the point where even the kind of meretricious deal that Professor Eagle referred to could legitimately be acceded to by a conscientious city council person as a view, say, gee, this stinks, but the city really needs it. And I think if that occurs, then it is constitutional under that standard.
Can I also just press you a bit for this distinction between use and purpose?
Yeah.
If you press that so far, won't you basically encourage cities just to change the form of ownership so that they won't be delegating to an agent the rights of control and execution of a particular development project? So if the city owns the project, if the city even owns arguably a shopping center or a railway station where they invite vendors in to sell retail food, which produces revenues for them, won't you basically just be encouraging that form of ownership over the form of ownership of a nonprofit or other kind of development corporation?
No, you're not going to encourage that kind of behavior from municipalities. On a practical level, municipalities don't want to pay for anything. They don't want to pay for city services, much less building a shopping center or something along along those lines. So I don't see that extreme ever being reached where we're talking about altering the form of property ownership or anything like that down the line. There will certainly be, and look, over time, our conceptions of what public use have modified a little bit over time, and things like canals or railways. Or riparian rights when it comes to riverbeds and things like that. There'll always be special allowances, for that, because it's not, even though in many situations the government is actually going to be owning that property. We all agree, at least on some level, that whether we're talking about a common carrier or talking about a canal, that we have to have because it is something that we all use. If we don't necessarily own it, I mean, things like that are gonna continue. Even if we're talking about just forbidding condemnations for economic development, those things that we've always had will continue. But I don't see municipalities getting in the business of owning shopping centers.
This is for Mr. Gall, and I never heard an answer to Mr. Byrne's point about the legislative process, public hearings, and a plan. What I heard you harping on was the fact that the plan was not satisfactory in the sense it was incomplete or it wasn't assured of success. And it seems to me, on the one hand, if you take the Poletown case, General Motors reserved the right never to operate that auto plant if conditions were not to its satisfaction. And in the reverse situation, we've had urban renewal plans or other redevelopment plans which are incredibly detailed, but no guarantee they're going to work out. Here in Cleveland, we have urban renewal projects that still aren't complete 30 years later. So what is your level of requirements that a plan be so detailed or assured or likely to succeed that it would pass your test, if any, for economic development under the public use provision?
Well, I mean, my first requirement, and I'll go back, I mean, I hate to sound like a broken record, but my first requirement is the plan won't involve taking somebody's private property for solely the purpose of economic development. I mean, that's a pretty easy standard for any municipality to meet. I know it's tempting, to go ahead and do that, but that's pretty easy to apply. Once again, if you're going to step back and say, okay, accepting for the purposes of argument that economic development can be a public use, then you do have to start making sure that there is some objective, public, I mean, if you're going to start talking in terms of public benefit, which I hate to do, you've at least got to make sure that benefit is actually going to accrue. And there are all sorts of things you can look at. When will that benefit accrue, if ever? I mean, is this something that's supposed to accrue next year? Is it supposed to accrue 5 years from now, 10 years from now, 20 years from now? What are we talking about here? I mean, are we going to, what are we building? What benefits are going to be produced by this? I mean, has there been some level of planning talking about we think these benefits are going to be produced? I'm not going to lay out everything that would need to be required, but it would have to be more than it is now. Because let me stress to you, right now, under the Connecticut Supreme Court's holding, the only thing that you have to do to pass muster under the Public Use Clause is simply say that you have an intent that these things will happen in the future. But that's not a standard at all. I mean, we're under that ruling. We are so far, the downward swing of the pendulum that there is no way under that standard to tell the difference between a public use and a private use, because anybody can say that they intend that this project will have economic benefits, and any project is going to have some conceivable trickle-down benefits to the public in terms of taxes or revenues. I mean, there's just no getting around that fact. So if the public use limitation is to mean anything, there at least has to be some standards. Unfortunately, we need to work those standards out. If we're going to cross that line, if we're going to say that economic development is a public use, if we're going to unleash that, and we're going to say that's okay, then we better at least do something to try and stuff part of that genie back in the bottle.
Much of the traction of the position of the petitioners in the case really comes from a lot of people's discomfort with what happened with urban renewal in the 1950s and 60s, both the displacement of citizens, sort of racist element to it, the bad urban planning that followed it, the highways, et cetera. But it's important to recognize that urban renewal was stopped not by changes in constitutional rules, but by statutory changes. Not only was the money eventually cut off, but before that, a great number of statutory procedural protections were created in terms of protecting existing neighborhoods and subjecting plans to a great deal of review. And so I really think that the political process can work in this case in order to maintain the benefits of eminent domain without throwing the baby out with the bathwater.
But it's like, we screwed up badly the first time, so trust us, we'll get it right. I mean, it took us 30 years to kind of screw it all up and figure it out, but trust us this time, we're okay. I mean, in the Kelo case, the NAACP, the Southern Christian Leadership Conference, the ARP, all submitted briefs, and what they pointed out is that minorities, the elderly, continue to be, target people who've traditionally been disfavored in the political process are always hit by this, and they are disproportionately hit by the taking of their properties for the benefit of private developers. That is a complete failure of the political process, and it shows that discrimination happens in this all the time. So, sorry, you had your chance, you blew it after 30 years, let's actually impose some constitutional restrictions on you.
None of those problems exist in this case.
Putting the arguments aside, what is the Supreme Court likely to do? What is the best prediction?
Well, I mean, do you want us to be like the exit polls in November here? I'll let him.
Professor Byrne?
Yeah, I think the city will win 7-2.
Wow, that's and why and in what standard?
What I think they will do is essentially reaffirm the standard of Berman versus Parker, but I think that they will express concern about some of the kinds of cases that, for example, the one that Professor Eagle referred to, without making a rule to deal with it, to say that they're concerned about it, but not fashion a rule to try to stop it. Because I don't think the Supreme Court has seen enough of this issue to have any sense of confidence that they can articulate a rule or a standard that are really going to weed these cases out, the bad cases out from the good cases. And I also think that they're terrified that if they do have much of a rule, that these cases are going to come to federal courts from state courts like a magnet picks up metallic dust. And if there's one thing that they don't want, it's that.
Different prediction.
A different prediction. I do, I believe we'll win. I think that's hardly a surprising prediction on my end, but beyond that, I'm not going to predict vote counts. I mean, this is an issue that cuts across what are perceived, I think, as the traditional left-right boundaries of the court. So I don't think you can say this is a conservative win 5-4. I don't think that's true at all. I think you'll see some unusual coalitions here in terms of whatever decision is reached. I do think this issue has percolated a lot. I mean, it has, in fact, percolated a lot in the state courts, and there have been lots of different standards that, in terms of evaluating, economic development as a public use, that have proved to be workable over time in several different jurisdictions, and the court often turns to what have the states done to try and articulate a rule that has done that actually in the regulatory takings context. So I don't agree that there's going to be that same level of discomfort with the court. But beyond that, in terms of whether we're going to get a Brightline rule or we're looking at introducing a little bit more of objectivity in whatever ruling that breaks down. I don't know because I don't want to end up being like the exit polls. But I'll just express hope that we win and confidence that we've got the better side of the argument. But beyond that, that's all I'll say.
Peter, let me ask you, what's the most difficult question that you think the justices will raise for the Kelo lawyers?
I'll write it down.
I think that they're going to be troubled by the lack of the fact that they don't have any handle on it. I think that one of the things that typifies the current Supreme Court more than anything else, and it's not a really liberal conservative thing, is that they really like to be in control. They like to have rules that allow them to give the last say on almost everything. And for them to sort of give that up, to sort of say, you mean all there is rational basis, I think that's sort of psychologically hard for these justices to accept.
Bert, what's the toughest question your team is preparing to answer?
I mean, I think the toughest question is probably, or I think a question that will be asked a lot, because it's a question that you often encounter, is this whole idea of will the sky fall? I mean, it's not so much a legal question as it is a practical question, and the justices are entitled to be concerned about the practical effects of their ruling, because that's what we hear all the time. Every time that if there is some sort of Brightline rule, the heavens will fall. And the answer to that actually is pretty easy, I think, in that if you look at states across the country that have said no, economic development is not a public use. In fact, the heavens have not fallen. You don't see those states submitting amicus briefs saying, "Oh, you've got to rescue us from this horrible constraint that's been imposed upon us." The fact of the matter is, development happens all over the country. Revitalization happens all over the country all the time, without the use of eminent domain for economic development. So, in that sense, it's a question that I expect to come up, and for the judges to really consider and think about. But I think the answer is there, and I couldn't tell you the hardest question I think they'll ask. That'd just be giving it all away.
Are there any other questions from the audience? Well, with that, I think I'd like to thank both of our distinguished debaters today. I think they've shed a lot of light on the arguments that we'll hear in action coming up February 22nd. I want to thank you all for coming to what has been a really wonderful day and a terrific symposium. So thank you very much.